case briefs, and so much more. LSData's got what you're looking for.
Vitronics Corp. and Conceptronic Inc., two companies that manufacture ovens used for soldering electrical devices to printed circuit boards, became embroiled in a 1996 lawsuit over a patent held by Vitronics for a specific method of reflow soldering. This method involves using a conveyor belt system to move circuit boards through a multi-zone oven to melt solder paste and form connections between devices and the circuit board. At the heart of the legal dispute was the term solder reflow temperature used in the patent. The case, Vitronics Corp v. Conceptronic Inc., was initially decided in the lower district court in favor of Conceptronic, with the court ruling that Conceptronic had not infringed on Vitronics' patent. However, Vitronics appealed the decision, arguing that the trial court had erred by relying on extrinsic evidence that contradicted the patent's specification and file history. The United States Court of Appeals for the Federal Circuit eventually heard the case, ruling in favor of Vitronics. The court explained that when interpreting the language in a patent, primary reliance must be placed on the language of the patent itself and the specific technical terms and definitions it contains. Extrinsic evidence, such as expert testimony or prior art, can only be used if the language used in the patent itself is unclear or insufficient. In this case, the Court of Appeals determined that the meaning of solder reflow temperature in the patent was clear, and therefore, extrinsic evidence should not have been relied upon. The court reversed the non-infringement judgment, awarding costs to Vitronics, and remanded the case for further proceedings, requiring the parties to present additional evidence and arguments on potential infringement.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class